At 6, the man who shot his girlfriend in the head last year and then shot himself has now been offered a plea agreement.
The girlfriend survived her injuries but still faces medical challenges. To make matters worse, her teenage son witnessed what happened. He spoke with our Mary McGuire. She joins us live in the newsroom tonight. Mary, there's a lot to untangle with this story.
And Randy, it's a very sad story. The victim in this case still has pellets in her body after being shot in the head with a shotgun and will deal with a long list of injuries for the rest of her life. Her family says they are shocked and angry that the man charged with 8 felonies in connection with this case would even be considered for a plea deal.
Then the cop asked me if there's any more guns in the house.
What happened last May is still fresh on the mind of Donovan Check. After spending the day at home in West Marshland, Wisconsin, with his mom and her boyfriend, the 15-year-old was watching a movie downstairs when he heard a gunshot.
Then I heard a fall, so I was like, okay, that don't really sound right. So I went upstairs. I see my mom on the ground, bleeding.
Not knowing what would happen next, he immediately called 911 and ran outside. Charges allege a day of heavy drinking and hallucinations led 30-year-old Michael Winquist to shoot his girlfriend in the head before turning the shotgun on himself.
I looked through our door and then he shot himself right then and there.
Both survived the shooting, and Winquist was charged with 8 felonies, including attempted first-degree murder. Check's mom, Christina Fickbaum, is forever changed, left with seizures, vision, hearing, and memory loss, and 12 shotgun pellets in her arm that can't be removed. In the month of April alone, she had more than 20 doctor's appointments. Her family was furious to learn a plea deal is now on the table.
I was shocked.
The Burnett County District Attorney confirms to Fox 9 all other charges would be dropped, including attempted murder, if Winquist pleads guilty to 1 count of reckless endangering safety and 1 count for being a felon with a firearm. The most time he could spend behind bars would be 12.5 years, a punishment that does not fit the crime for a family that has been through such a traumatic ordeal.
He's gonna be there for however long, and then my mom's gonna have this for the rest of her life, and it's just not right.
Now, another court hearing is set for Wednesday, where the DA will have to explain how and why this deal all came to be. If the judge accepts it, a plea hearing will then be scheduled. Christina and her family tell me they will be there every step of the way to show their opposition to this. Mary McGuire, Fox 9.
Understandably. Thank you, Mary. Authorities
Can the jail hear me?
Hear us?
Yes, I can hear you. That's great. Excellent. And you were visible there for a second. There we go. That's great. Thank you.
You're welcome.
We will go on the record in the matter 24 CF 143, State of Wisconsin versus Michael Winquist. The state appears through District Attorney Kevin Schmidt in person. We have Eugene Harrington, Defense Counsel, in person. Michael Winquist appears by video conferencing in custody in Burnett County Jail. We're set here for a status conference. Mr. Harrington, can you please update the court?
Case is settled, Judge.
Can you please provide the court with the agreement that's been reached?
Count 1 will be amended to allege second-degree reckless injury, contrary to 940.23 sub 2.
940.23
sub 2.
Sub 2, okay.
With a dangerous weapon modifier. Maximum penalty for that offense is 12.5 years plus 5, 17.5 years is the max. Actually, it's 12.5 years is the max confinement. He'll also plead guilty to count 2, possession of a firearm by a felon. That's 1 count of that. The other counts will be dismissed. Parties will request a pre-sentence investigation. Both parties free to argue at sentencing. Propose that the parties agree to recommend concurrent sentences as to the amended count 1 and count 2. Mr. Winquist will prepay $10,000 as and for partial restitution. I've now checked with the veteran service officer. Once he's confined to a correctional facility on a sentence, whether it's a jail or prison, 60 days thereafter, he will lose the vast majority of his VA benefits. He retains 10%. Upon discharge from incarceration, monthly restitution will again be reviewed and extended as the facts may warrant. Conditions of extended supervision or probation include the standard conditions: no contact with the victim, her family, or other friends identified through discovery. If acceptable, a list of persons will be prepared and presented to the court at sentencing. The parties will prepare a stipulation of facts which support the factual basis for the conviction. And I think I have accurately set forth the plea agreement. Mr. Schmidt?
So it's free to argue.
Yes.
But the state is not capped. The state can argue all the way up to the maximum possible penalty, except that the agreement is concurrent.
Yes.
Ms. Bauer? I'm going to guess that the agreement was not discussed with the victim prior to.
And I don't agree with that.
All right, the victim needs to come up here to the black desk, and you either state your name or just your initials, whatever you feel most comfortable with.
My name is Christina Fickbaum.
And I'm going to say that I know that you're anxious and you seem a little frustrated. But remember, please speak slowly, and please make sure that you can speak loud enough so that my court reporter can hear, and that so I can hear, okay?
I was discussed with their agreement and I don't agree with it because 17 years is 17 years. Congratulations for Max. My feeling is that my hearing is gone forever. I have serious brain injuries that they've already diagnosed. That is forever. Right now, my nerves are dying out in my legs. Long-term looks at like dementia and possible wheelchair. I have surgeries coming up left and right, but that's forever. My son, you can't erase it. And he has nothing for doing it in front of my son. It's just not fair. For the rest of my life. That's all I have to say.
Thank you. Let me go have a seat. Thank you. Mr. Schmidt, would you feel more comfortable, and Mr. Harrington more comfortable briefing, or not briefing, but just doing a memorandum as to why this is in the public interest, or would you like to make argument here today?
I can do it
for
today.
consideration?
I am not surprised with this. My proposal to Mr. Schmidt from February 28th about the facts to support the conviction, I would prefer to write those down and outline to the court why we think this is an appropriate disposition or appropriate plea. The facts will tie into the discovery. My proposal to Mr. Schmidt then was that I would prepare the statement of facts, which will support the conviction, and that he and I would talk those over, negotiate what the facts were before the plea came about, and that was the basis for our agreement. And I think that's what I'd like to do, Judge.
And I actually prefer it in writing as well so that I can digest it, because I only know the facts as they're laid out in the criminal complaint. And that's the only facts that I know from, I would say, the police standpoint and the state standpoint. So how long do you need to prepare a written memorandum or brief as to why you believe that this agreement is in the public interest?
What I'd like to do is, if you could give me 2 weeks, then I will prepare a draft. I will get it to Mr. Schmidt, and Mr. Schmidt may not agree with some of those facts, which is what was originally contemplated. And let's submit it there after. If I could have until April 18th. And then I'd suggest we set this for a plea after that.
I think Attorney Harrington and the court are referring to two different things. Attorney Harrington's talking about what the factual basis of the plea is. The court's doing the public interest inquiry right now and asking if we want to give a statement of why the agreement's consistent with the public interest.
Well,
That's why I'm saying
one and
I
the
can do
same.
this today.
yeah, I assume that they were one and the same, but
I believe that they would be one and the same. Because if you're going to both the state as well as the defense stipulate as to the factual basis, then that would mean that you're stipulating as to the facts. And that would be why, and plus you'll make argument as to why you believe that the agreement is in the public interest, because you're going to have the stipulation as to fact, and you'll have your little argument as to why, or not little, you'll have a argument as to why you believe that the court should accept the agreement that's been reached, and why you believe that it is in the public interest to amend count 1 and to accept a plea for the amendment and for count 2. But I believe, as Mr. Harrington has said, if you, the state and defense, have, as part of your agreement, agreed that you both are going to stipulate as to facts to present to the court for a plea and sentencing, I think that it's pretty vital as to the public interest. So you want until the 18th?
18th of April is, well, that's Good Friday.
Yeah. Why don't we do until the 28th of April?
Fair enough.
And then Mr. Schmidt, how about May 12th?
Mr. Schmidt and I are gonna,
You're just
Yeah,
gonna work
it-
together?
we're gonna work.
It has to be stipulated, it has to be one
okay.
document.
All right, so you'll work together? Okay, so then April 28th. And then let's get a status date. Can you do May 8th at 11:45? All right, May 8th at 11:45. No?
We do that. That's that board of directors that I sit on. We meet at 9 o'clock that morning, 11:45, 11 might be kind of nip and tuck.
What about May 7th at 11:45?
May 7th, 11:45 works.
All right, so May 7th, 11:45. And the court will then have had an opportunity to review the document filed by both sides. Well, together. Anything further from either side?
No, Your Honor.
No, Judge.
Okay. Then we are adjourned. Can you do May 8th at 11:45? All right, May 8th at 11:45. No?
We do that. That's that board of directors that I sit on. We meet at 9 o'clock that morning, 11:45, 11 might be kind of nip and tuck.
What about May 7th at 11:45?
May 7th, 11:45 works.
All right, so May 7th, 11:45. And the court will then have had an opportunity to review the document filed by both sides. Well, together. Anything further from either side?
No, Your Honor.
No, Judge.
Okay. Then we are adjourned. Thank you. We will go on the record in the matter 24 CF 143, State of Wisconsin versus Michael Winquist. The state appears through District Attorney Kevin Schmidt in person. We have Eugene Harrington, defense counsel in person. Michael Winquist appears by video conferencing in custody in Burnett County Jail. We're set here today in this matter for a status conference. At the last status conference on April 7th, 2025, the court was informed of a plea agreement that had been reached by both sides in this matter. It was recited on the record. At that time, the court did inquire as to why it is in the public interest and that it be in a written statement. However, the court has, at that time, the court was informed that there would be a joint stipulated factual basis document, both by the defense as well as the state, as well as a joint public interest document by the state as well as the defense. The court has not received a joint stipulated facts or stipulated public interest argument. The court has only received documents from the defense, one-sided, have not been approved by the state. And therefore, the court only has the defense's side as to the facts as well as to why the defense believes that the plea agreement is in the public interest. Before we continue, Mr. Schmidt, please place what the agreement is on the record.
Sure. My intent today is to talk about the public interest. The plea agreement be pleading to second-degree reckless injury with the dangerous weapon modifier. That's a maximum penalty of 17.5 years confinement, 5 years extended supervision, $25,000, and also felon in possession of firearm. That has maximum penalty of 5 in, 5 out, same amount of money. The agreement be they'd run concurrent to each other because they were the same course of conduct.
All right, and so that's the agreement.
And then both sides would be free to argue.
And free to argue. So it would be from the agreed perspective with this agreement, it would be a maximum total of 17.5 years of confinement with 5 years of extended supervision.
Yes.
All right, before I get into argument, Ms. Bauer, victim witness, do any victims wish to make any statement as it relates to the agreement that's been recited on the record?
Oh, Your Honor.
All right, they would just like to rely upon what was stated at the last hearing? This is an opportunity for you to provide anything that you wish for the court to know as it relates to the agreement that's been extended. And when you get over there, you can state your name or your initials.
My name is Christina Fickbaum.
And please have the microphone to you. And I know that this could be being in court can be a bit stressful and cause anxiety. But when you speak, if you can speak clearly, so my court reporter can take everything down.
Okay. I just want to say, like, even more stressing about how much more serious my medical conditions have become. In the month of April alone, I've had 20 plus appointments, doctor appointments in 24 business days. I mean, it's just getting insane. And, I completely do not agree with this. And I wish that it wasn't so one-sided, because it's not fair. He gets to 3 hots on a cot, and me and Donovan have to be out here surviving, dealing with all the pain and anguish that he has caused in our life.
Are you opposed to a trial?
No.
Anything further you would like the court to be aware of?
Not at this time, Your Honor.
All right. Thank you. You may return to your seat. Mr. Schmidt.
Thank you. The reason we reached this disposition is because this is the offense that happened. This is what the evidence supports. It's what Michael Winquist did. We don't pick a sentence based upon the effect of the victim and then work backwards and pick what offense we want to say happened. That's not how the law works. We look at the evidence and what the law is, and then we pick the appropriate sentence based upon the effect of the victim within that. When this case first came in, we did the probable cause statement as attempted first-degree intentional homicide. We did that where the only evidence we had was what we saw at the scene, and we did an interview with Michael Winquist where he admitted to shooting the victim with the gun. He didn't have a reason he could offer for it. He laid the basis for some sort of NGRI adjacent type of offense. We didn't have an opportunity to interview anyone else. Obviously, the victim was not conscious. At the time, we thought the victim was likely to die because she had been shot in the head with a shotgun. We hadn't interviewed the child yet. There was a great gap between the probable cause time and me filing the complaint. I am the one who filed the complaint charging Mr. Winquist with attempted first-degree intentional homicide, the various counts of felon in possession of firearm, and the handling of the firearm while intoxicated. In that time, we tried to gather as many statements as we could. We knew the defense would be predicated primarily on the intent to kill. That was what we were expecting. What we gathered in the meantime, the main pieces of back up a bit. The court could tell at the prelim what we were predicating intent to kill on, both at the probable cause state for the statement of arrest and the preliminary hearing, was heavily reliant on the argument that where the victim was shot in the head with the weapon that was chosen, a 12-gauge shotgun, and where that location was in a home, not outside, not like hunting, something like that. We predicated it heavily on that, and also on the argument that there appeared to be a narrow spread towards the head. We argue it must have been close range. Based upon that, we made the argument that it had to have been intentional because you couldn't accidentally do something like that. That got us past probable cause. Attorney Harrington argued against that at the preliminary hearing. He argued you need an expert for that. You don't need experts for preliminary hearings. State lab says they can't do any analysis like that. It's not possible. We can't get any testimony from an expert. The gun was so far away. It was at such and such angle. That doesn't exist. You can't do that. So in the meantime, we also collected statements from people looking for evidence of intent to kill. So back up. The difference between these two offenses is for intentional homicide, the state has to show the defendant has an intent to kill. Pattern jury instruction for that's about a page and a half. What it boils down to is we have to actually show the goal of the defendant was to kill the person. They intended to do that, to end their life. If you intend to kill someone, you do something to kill them, you kill them, it's first-degree intentional homicide. If you do it and you don't kill them, you fail, it's attempted first-degree intentional homicide. The offense we're talking about is a reckless conduct offense. The offense that we're asking the court to do here today would be the offense of causing great bodily harm, which is the highest level of injury you can cause to somebody by law, by conduct that intentionally exposed them to a substantial and reasonable risk of said great bodily harm or death. That is exactly what happened. If the victim had died, it would be a reckless homicide. There's no such thing as attempted reckless homicide. This is the offense that exists instead of attempted reckless homicide. That's why you read case law about attorneys trying to use this as a lesser included for that type of condition. The evidence we did find for tried to collect evidence for intent to kill. The three most important pieces of evidence, the things that are most persuasive as to whether it's there or not, were the recorded statements of Michael Winquist, the defendant, the victim who just spoke, and their son, who was a witness at the crime scene. Michael Winquist was interviewed around the same time this happened. He was in the hospital with a big bloody gash down his face from when he had shot himself. Michael Winquist freely admitted that he shot the gun. His exact wording was, "I woke the fuck up and blasted." There was no ambiguity that he said he was shooting the victim. So police quickly moved on to why Michael Winquist couldn't offer an explanation as to why. He seemed confused himself. It seemed legitimate confusion. So the police attempted to try to see what he had to say about their relationship or the past leading up to it. He said his relationship with the victim was fine. He could not recall any arguments that led into this. He admitted to drinking. He said he only slept a few hours over the past 3 days. He related possibly being in a dreamlike state. We also interviewed the child. The child is an important witness in this case because the child is the only one who did not suffer a severe head trauma. As I said, Michael Winquist attempted to shoot himself and bash his own head in the ground. He had severe head trauma. The victim was shot in the head. Both of them were highly intoxicated at the time this event happened. The child's important because he's a sober, neutral witness. The interview of this child was a compelling one. He came off as very persuasive. Many things he said were corroborated by the scene, by statements by Winquist, and by statements by the victim. The interview did not have suggestible questions. The child's responses were in narrative format. The child also offered no explanation for what had happened. He said that Winquist and the victim had started drinking early in the day while doing yard work, and they were both drunk by the time the shooting happened. The child explained that he's somewhat of an expert. He's good at identifying when Winquist and when the victim were intoxicated because he sees them intoxicated so frequently. He knew Winquist was intoxicated at the time of the shooting because he was swaying and couldn't walk steady. He knew that the victim was intoxicated at the time because she was steady. He said that when she hasn't been drinking, her hand shakes and she's shaky in general. His expertness at identifying the intoxication levels of the individuals turned out to be correct, as the blood alcohol results showed Mr. Winquist was about a 0.215. The victim was about a 0.297. He said that he didn't really see any argument leading up to the shooting. The only argument he saw that all day that they had happen prior to the shooting. It was an argument where the victim and Mr. Winquist were arguing with the child's father on the phone about money. Both the victim and Mr. Winquist were mad at this person. And then after the phone call ended, they started yelling and swearing at each other. With Mr. Winquist mad about money he gave the child's father, and the victim trying to assuage him by saying they'll have their day in court, as the child said. The child also related that they had gone out together to get snacks at some point in the day. He didn't see them fighting physically at all in that day. Child's actually relation of how the event happened is the house was silent. He was falling asleep while playing video games. He heard a crash upstairs that he assumes was Winquist getting up and moving around and possibly falling down or moving things around. Then heard a gunshot, which the child said he originally didn't think anything of. That Winquist frequently shoots red squirrels with a gun. And then when he heard something drop, he was worried. He came up, he saw Mr. Winquist with his mother severely bloodied. He said that he asked Winquist, what did you do to my mom? He said Winquist said to him, I don't know. I thought I was dreaming. The child then was asked about the relationship between Winquist and his mother. He related he could only recall one violent incident in the past between him where he saw Mr. Winquist hit the victim in the back and he tried to intervene. His mom the victim prevented him from contacting the police. She didn't think that the incident was severe and should be reported. The child said that argument I described was only 10 minutes. And it was not contemporaneous immediately before the shooting. Finally, the police interviewed the victim. The victim's interview was probably the most compelling piece of evidence in the case. The victim was interviewed in the hospital just a couple days after the shooting. You would expect that she would have been addled from drugs or had slurred speech. She was not. She spoke clearly, concisely. There was no delay. There were times when the investigator interviewing her would say something wrong. She'd identify it, correct him. It turned out she was right and not the investigator. Her recall was impeccable. It was also consistent with what the child said and what Mr. Winquist said. What she said was that she couldn't recall the exact incident of getting shot. Of that, all she could say was she remembered hearing something and seeing something, but couldn't say what in the kitchen and then nothing. She could recall the day and days before, as well as their relationship and things of that nature. She said that Michael Winquist had, I take that back to, the one thing I forgot to mention, the child had said that Mr. Winquist, in addition to drinking, had not slept that week and was watching horror TV shows that he thought was relevant for some reason. The victim said that Mr. Winquist had drank for 4 days and was sleeping on and off for 2 days when the shooting happened. She said she was trying to make him sleep because of the staying up and worry about his condition, and that he was throwing up preceding the event. She related that as for their relationship, because she couldn't remember anything about the incident, the investigator tried to ask about the relationship to see if there's anything there to form intent to kill. He asked her, I'm going to be precise with this. He asked her if they ever had any physical altercations. She recalled the same incident, the child related. She said that Mr. Winquist was sleeping and suddenly got up and popped her. And then her son tried to intervene. While her son was intervening, Winquist was saying something like, sorry, I was sleeping. The investigator asked her, were there any other incidents of Mr. Winquist attacking or being violent while sleeping or in a dreamlike state? She said yes. She said he's fighting people in his sleep frequently as they sleep, so he'll be swinging and kicking in bed. The investigator asked the victim, are there like actual domestic violence incidents? She said no. She said the worst he does is hit walls. She said that they have mainly verbal arguments. He asked her if he's ever threatened to kill her before. She said never. He asked her if he'd ever threatened to harm her. She said no. He asked her, has he ever made her afraid for her safety? She said when he's yelling or raising her voice, she just walks away. The investigator asked the victim if she had any idea why Winquist would have shot her. She suggested it having something to do with being in a dreamlike state. The victim believes that Mr. Winquist has PTSD, but doesn't know what the cause is. Though he served in the Army, he didn't go overseas. She is just aware that she believes he has PTSD. These three interviews are consistent with one another. They're consistent with the evidence at the scene. They paint the picture of criminal recklessness where Michael Winquist, who is not allowed to drink because he had conditions of probation prohibiting it, and not allowed to possess a firearm because of his felon status from an OWI conviction, broke those rules. He has the history that he knows of where he gets in sleepy, dreamlike, combative states, and he deprived himself of a great deal of sleep while drinking profusely with ready access to a firearm he's not supposed to have. These interviews would be the reasonable doubt of a first-degree intentional homicide, and they're from the victim and the only sober witness, the child. The victim in this interview, by the way, was not sympathetic to Mr. Winquist. She expressed desire that he did successfully kill himself, that she's afraid and she wanted a cash bond set. Her tenor was decidedly hostile. This was not someone cutting excuses for Mr. Winquist. They were interviews given before the benefit of reading any criminal complaint, before getting a defense attorney to talk about theories of defense, before watching the prelim and hearing the theory of defense, or before talking with me about what the defense's theories of defense are and how the evidence would fit into those. This was before the victim indicated to us that her doctors have concern of neurocognitive degeneration and dementia affecting her mind. The victim and child gave these statements contemporaneous with when this occurred, and they had high credibility in the interviews. They gave their statements not knowing what the eventual charges would be and the defenses to them. The strongest defense in this case to first-degree intentional homicide is to attack the intent to kill element. It's for the defendant to play those recorded interviews and say, you should believe the victim and the child. If you believe them about these dreamlike fighting states and the lack of sleep leading up to this, then that's a reasonable doubt. And you should return a verdict of not guilty. The reason the state reached this agreement isn't because we think the maximum penalty of attempted first-degree intentional homicide is too much. We looked at the evidence and we looked at the charges and what could be proven and what the evidence says. I don't pick what the elements of the offense are. I don't pick the evidence the police find. This is the evidence. This is the case. The effects on the victim are horrific. They are life-altering. They're is no sentence that could be given to really appreciate that. In fact, I remember back in September, the victim's mother said to us, even a plea to the attempted first-degree intentional homicide didn't have a severe enough penalty, and asked if there's anything we could do about that. This agreement where he's pleading to what he did and both parties are freely able to argue the sentence is plainly in the public interest. Thank you.
And so what I'm hearing from you, Mr. Schmidt, is after reading all of the discovery information and all of the investigative documents that you've been provided, that you are telling the court that you cannot prove beyond a reasonable doubt to a jury count 1 first-degree intentional homicide as an attempt.
After reviewing the reports, watching the videos, consulting with the investigators, consulting with the crime lab, reviewing the NGI report, which in finding NGI is not appropriate because of Wisconsin's prohibition against voluntary intoxication, plainly raised questions about the mens rea and the intent element. Reviewing all of those things, this is the offense. I've had numerous meetings with the victim, and as you heard, the victim's main problem with this is the penalty needs to be more severe because the consequences on her have been so severe, and they have.
All right, thank you. Mr. Harrington?
Thank you, Judge. I filed the 5 or 6 page memorandum the other evening. I'm reasonably sure that the court has reviewed that.
Yes, I have.
And I agree with Mr. Schmidt's rendition summary of the discovery. Both Mr. Schmidt and I have reviewed that discovery, and this is the crime. 2nd degree recklessly causing injury with the firearm enhancer. From the very beginning, when the court appointed me to represent.
And I'm sorry to interrupt, but this includes the firearm enhancer, but not the domestic abuse enhancer? Because they were in a relationship.
You mean the domestic abuse
Or the
surcharge?
surcharge, yes.
The enhancer does not apply to this fact pattern.
But it would be the domestic abuse surcharge. Is that applicable?
Yes.
Okay, so it would be, you're arguing for that with the dangerous weapon modifier with the domestic abuse surcharge.
The surcharge wasn't part of our plea negotiations, but I don't think that's part of the plea arrangement anyhow. That's something you decide at the conclusion of this case, whether he's assessed that surcharge or not. That's
part of the, that would need to be part of the modifier as part of the charge.
By statute, the court makes that determination at the end of a sentence. I know parties frequently negotiate about it. It's $100 surcharge, and since his rights to firearms are already gone, it's $100 surcharge.
Plus, having that on his record, domestic abuse. A criminal record. All right, Mr. Harrington.
Mr. Schmidt and I reviewed the discovery, and through various conversations by email and directly in his office, this is the crime that both he and I are convinced that Michael committed. It's a serious crime. My comments in no way should be construed as criticizing the victim, because it's a horrible crime that's going to has dramatically impact her life and will do so for the rest of her life. The discovery is the discovery. Mr. Schmidt's comment about DA's charge cases on the basis of probable cause, and as cases move towards trial, discovery takes place, scientific evaluation takes place, and cases get resolved on the basis of plea negotiations and legal analysis. I, from the very beginning, thought that there might be a problem, that the best defense for Michael's case would be showing before a jury that there was no intent to commit the homicide. There was no specific mental purpose to take her life or engage in conduct that was practically certain to cause death of another human being. He had a nightmare. He had a history of nightmares. Illegally, he kept a loaded shotgun in close proximity. He shouldn't have had it at all, but he had it in a bad place. And the result is unfortunate for all concerned. We think this is in the public's interest. It resolves the case. I noted in my memo, one of the factors is the ability or the capacity to make restitution. The current restitution demand is $12,582. Our plea is that Michael pay $10,000 at the time of sentencing or at the time of disposition. Michael's account presently has $13,349.37. And that we're not going to probably do the plea in the sentencing today.
Sorry, what did you say?
He has $13,349.37. He receives veterans benefits on a monthly basis of $2,489.96. There'll be money to pay, certainly the $10,000. There'll probably be money when we get to the disposition to pay the entire $12,582.23 that's part of the restitution at this point. Otherwise, my memo outlines our legal analysis, and the court's read it and will consider it. We would stand on that.
I have read it. I have considered it. You're asking for second degree. Why not first?
The difference between originally my proposal was first without the dangerous weapon modifier. The difference between first and second degree is we'd be talking to a jury about this abstract idea of whether the circumstances show utter disregard for human life. That's such an abstract legal term that it's not a good idea to go for that. And the compromise was adding the dangerous weapon modifier to get us to the same maximum penalty as first degree.
All right. Any final thoughts?
Not from the state, Your Honor.
Thank you, Judge.
All right. I have heard your arguments and I have your written submissions. I am going to, and I've heard the victim both here today as well as at the last hearing. I'm going to let this soak in and then look at the factors that the court has to consider. They were stated clearly in Mr. Harrington's brief. However, I was aware of them prior to, but I have to look at those factors and whether or not they have been met for the public interest as argued by the state, because quite honestly, I thought I was going to get a joint statement here today, a joint argument. And I need to know, that's one thing I need to know as well. I was told I was going to get a joint stipulated factual basis, and I do not have one.
I can explain that, Judge. I prepared what was a proposed stipulation. Mr. Schmidt didn't necessarily disagree with the facts, suggested that as an alternative, I take the 30-page criminal complaint and use that, delete things that I disagreed with. I had already prepared this memo, and when looking at 30 pages versus what I have already done, I did it that way and just changed the documentation such that it said not a stipulation, but rather the defendant's submission. My primary purpose there was to outline the factual basis to support the plea. My original thought was I was going to do that at the time of the plea, rather than rely, as we normally do, judge the factual basis in the complaint will be the factual basis for conviction. There's some things in the complaint that we disagree with to a certain extent.
Am I getting a stipulated factual basis?
I guess I can give my perspective. I never understood why we were trying to stipulate to a factual basis. I've never seen a court require that. The court always colloquies
That
with the
was the
defendant.
suggestion, or I was told that by Mr. Harrington.
Harrington said he was going to submit his defendant's version of events for a factual basis.
Do you want
The
me to
court-
have the transcript? Because I was told I was getting a stipulated.
I suggested
joint.
it be stipulated. We were not able to reach a stipulation on the factual basis. So I submitted the defendant's admissions as a factual basis. Mr. Schmidt and I, Mr. Schmidt was busy with other legal cases, and we just were not able to fine tune this. And if there's a fault here, Judge, it's not Mr. Schmidt's. That rests with me.
I mean, it's even in the minutes. It says prepare a stipulation of facts. And an agreement for the parties in the public interest. Attorney Harrington, then you made a statement. Then the state made a statement. And we scheduled it for today.
So allow me to finish what I was trying to say. Attorney Harrington sent me a document that literally contained everything in it was in the criminal complaint. I said to him, I don't understand why we're even doing this if all that's going to be is what's in the complaint minus a few things, and then putting in like what the defense theory of defense is. I asked him, are you trying to prevent me from relying on anything in a sentencing argument? He said no. And then I questioned why we're doing this at all. I didn't get a response. The defendant submitted this document. I read it, and to be honest, it doesn't look like a stipulated facts for the case. It looks like a sentencing memorandum to me. Most things have nothing to do with the facts of the case.
As of now, yes, it did. I would have liked to have heard from the state prior to today with that statement that you just said on the record. So I was expecting something completely different for today.
The first version of the document I was given was a week and a half ago.
I know, but I was expecting not that this would take a half an hour. That's why I said it for 15 minutes. I was expecting to have the writing in front of me so I could have read it. I could have been prepared. I could have heard a brief statement by victim. If victim wanted to make another statement, I could have made a ruling. But now we've been a half hour in and I can't do my job. So that's why I am taking it under advisement. I'm hearing all of the arguments, and I will probably do a written decision. But we can schedule June 19th at 1 for oral if that works. Or June 23rd or 26th.
June 19th works for me. That's a Thursday. And
But if I do written, obviously it'll be out a lot sooner.
23rd or 26th. I'm available afternoon, all three of those days, Judge.
I would only be available in the morning on those other days, but I can do June 19th at 1.
That works.
All right, June 19th at 1. We'll just set it as a backup for a whole half hour. And if I do a written, then it'll be out earlier.
And thank you, Judge. I apologize for not submitting something written. I just misunderstood what happened at the last hearing and what the court was asking for. I wanted to say it verbally because I thought there was public interest in saying the reasons for the agreement.
Thank you.